In the case of Murlidhar Chiranjilal versus Harishchandra Dwarkadas, a contract was entered into between the appellant and the respondent through one Babalal for sale of certain canvas at rupee 1 per yard. The delivery was to be made through railway receipt for Calcutta free on rail Kanpur. The cost of transport and the labor charges were to be borne by the respondent. It was also agreed that the railway receipt would be delivered on 5th August 1947. The appellant failed to deliver the railway receipt and informed the respondent on 8th August 1947 that booking from Kanpur to Calcutta was closed and the contract has become impossible to perform. Consequently, the appellant cancelled the contract and returned the advance that was received. The respondent did not accept that the contract had become impossible to perform and informed the appellant that it had committed a breach of contract and was liable for damages. The main issues that were raised in this case were the first one is whether Babalal had acted as an agent of the appellant in this contract. Second one is whether the contract had become impossible of performance. And the third one is whether the respondent was entitled to damages at the rate claimed by it. The trial court held that Babalal had acted as the agent of the appellant in the contract and the appellant was bound by it. And the contract had become impossible of performance and it was the respondent's duty to buy the goods in Kanpur. And also the respondent failed to prove the rate prevalent in Kanpur on the date of breach and was therefore not entitled to any damages. On appeal by the respondent, two main questions were raised before the High Court. The first one is about the impossibility of the performance of the contract, and the second one is the liability of the appellant for damages. The High Court held that the contract had not become impossible of performance since it had not been proved that the booking between Kanpur and Calcutta was closed at the relevant time. And also it was held that the respondent was entitled to damages on the basis of the rate prevalent in Calcutta on the date of breach, and the suit was decreed for rupees 16,946. The same question which were raised in the High Court was also raised in the Supreme Court by the appellant. The court thought it unnecessary to decide the appeal on the impossibility of the contract and necessary to raise a question on the liability of the appellant for the damages. The question therefore that arises is whether the respondent has proved the damages which it claims to be entitled for the breach. The court referred to Section 73 of the Indian Contract Act, which deals with the compensation for loss or damage caused by breach of contract. The relevant part of which the court took into consideration was that when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach or which the parties knew when they made the contract to be likely to result from the breach of it. The explanation says, in estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into consideration. Moving on to the contentions of the appellant. Firstly, the contract was for delivery free on rail Kanpur, and the respondent had to prove the rate of plain and not colored canvas at Kanpur on the date of breach, but the respondent failed to prove its rate and therefore was not entitled to any damages. And also, when goods are available in the market, it is a difference between the market price on the date of breach and the contract price which is taken into consideration for the measure of damages. Here, if similar canvas was not available in the market, it was a duty of the respondent to buy the canvas in Kanpur and rail it for Calcutta. And if it suffered any damage because of the rise in contract price, it would be entitled to such damages. But here, the respondent failed to prove the rate of similar canvas in Kanpur on the relevant date. Moving on to the contentions of the respondents relied on that part of Section 73 of the Contract Act, which says that the damages may be measured by what the parties knew when they made the contract to be likely to result from the breach of it. Here, the parties knew when the contract was made that the goods were to be sold in Calcutta. Therefore, the price in Calcutta is to be taken into account while measuring of the damages. Reliance was placed on Re and H Hall Limited versus WH Pim and Companies arbitration, and also Victoria Laundry Windsor Limited versus Newman Industries Limited. These two cases are special cases, and the question is whether the present case is similar to them. Moving on to the analysis by the Supreme Court, the court held that there was a breach of contract since the contract was to be performed by the delivery of railway receipt free on rail Kanpur by the appellant to the respondent on 5th August 1947, but this was not done. The two principles on which the damages in such cases are calculated are well settled. The first one is as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed, as far as money can do it, is in a good situation as if the contract had been performed. And the second one is it is the plaintiff's duty to take all reasonable steps to mitigate the loss consequent on the breach and debar him from claiming any part of the damage which is due to his neglect to take such steps. The second principle was followed in British Westinghouse Electric and Manufacturing Company Limited versus Underground Electric Railways Company of London. Therefore, if the contract is performed at Kanpur, it was the respondent's duty to buy the goods in Kanpur and rail them to Calcutta on the date of breach. And if it suffered any damage because of the rise in contract price on the date of breach, it would be entitled to damages. Even if the respondent did not buy them in the market at the Kanpur on the date of breach, it would be entitled to damages on proof that the rate of similar canvas in Kanpur on the date of breach was above the contracted rate. But the respondent did not make any attempt to prove the rate of similar canvas in Kanpur. Also here, the buyer had purchased the canvas for resale, but it cannot be inferred that the seller knew that the goods were for resale in Calcutta. It was open to the buyer to sell them anywhere it liked. Therefore, this is not a case where it can be said that the parties knew when they made the contract that the goods were meant for sale in Calcutta alone. This was an ordinary contract in which it was open to the buyer to sell the goods where it liked. The court found it apt to quote the case of Chao and others versus British Traders and Shippers Limited with regard to the case in hand. Therefore, the respondent here had to prove the market rate at Kanpur on the date of breach for similar goods, and that would fix the amount for damages. But the Supreme Court held that the respondent failed to prove the rate of similar canvas in Kanpur on the date of breach and therefore was not entitled to any damages.
I would like to provide a holistic view of damages under Indian law through this case. So, under the Indian law, a contract is defined as an agreement enforceable by law. One of the important Latin principles on which the law of contract is based on is consensus ad idem, which means meeting of minds. A contract cannot be treated as complete unless there is an offer by one party and an acceptance by the other party. If the parties to a contract abide by all the terms and conditions of the contract, a cause of action for breach would never arise in the first place. Breach often occurs due to the failure of one party to perform its obligations under a contract. In such a scenario, the party committing the breach is required to pay damages to the aggrieved party. Damages under the Indian law are governed by the Indian Contract Act 1872, the ICA. The word damages means a monetary compensation that is awarded by a court in a civil action to an individual who has been injured through the wrongful conduct of another party. Damages may be calculated on the basis of legal principles enacted in the statute, or even the parties may, during the execution of a contract, decide that in a case of a breach, uh, in fact, the defaulting party shall be liable to pay a stipulated amount or forfeit the amount which the defaulting party would have already deposited with the injured party. The amount decided shall be a reasonable compensation and a genuine pre-estimate of damages, known as the concept of liquidated damages. The whole idea behind awarding such damages is to put the aggrieved party in the same position as it would have enjoyed if the contract had been performed. Now, in India, the principles pertaining to assessment and award of compensation in case of breach of contract are laid down in sections 73 and 74 of the ICA. Section 73 of the ICA provides for the compensation for loss or damage caused by breach of contract, which means that in the event of a breach of contract, the aggrieved party is entitled to be compensated by the party causing such breach, like I mentioned before. But the breach should have arisen as a natural consequence, or the parties had expected such a situation to arise while entering into the contract. Under this section, the compensation is not provided for any remote or indirect loss or damage caused to a party. So, as an illustration, I would like to provide an example. A contracts to make some repairs in B's house in a specific manner, as stated in the contract. B pays an advance to A for starting the work. After the completion of the work, B observes that the work does not conform to the specifications stated in the contract. Therefore, A is liable to pay the cost of repairs in order to conform it to the specifications of the contract. And that's where we come to our current case. Supreme Court of India in Murlidhar Chiranjilal versus Harishchandra Dwarkadas. And this case set out principles uh, based on which damages shall be calculated in the event of a breach of a contract for sale of goods. So the Supreme Court held that it is well settled that the two principles relating for to compensation for loss or damage caused by a breach of contract, as laid down in Section 73 of the Indian Contract Act, uh, read with the explanation thereof, are that as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed as far as money can do it in as good a situation as if the contract had been performed, but that there is a duty on him of taking all the reasonable steps to mitigate the loss consequent on the breach and debars him from claiming any part of the damage which is due to his neglect to take such steps. So this was what the Supreme Court held. And I would like to draw your attention to another case, where in the case of Pannalal, Janki Das versus Mohanlal. So in that, Patanjali Shastri J of the Supreme Court of India observed that the party in the breach must make compensation in respect of the direct consequences flowing from the breach and not in respect of loss or damage indirectly or remotely caused. He further provided that the rule is based on the broad principle of uh, restitutio in integrum. And that's to say that the party who has suffered the loss should be placed in the same position as far as compensation in money can do it. And as if the party in breach had performed his contract or fulfilled his duty. So the two cases that I've mentioned quite have the same spirit, the same verbatim. And Section 74 of the ICA provides for compensation for breach of contract where penalty stipulated for, which means that when a specific amount is mentioned in a contract as the amount payable in the event of breach or any other stipulation regarding a penalty, it is provided in a contract, and in that case, the aggrieved party is entitled to get the amount without proving the actual loss or damage caused. But the award should be reasonable, and in no way it should exceed the amount mentioned in the contract. Section 74 of the ICA makes an attempt to cut across the general principle in the English common law, where a genuine estimate of damages by mutual consent is considered as liquidated damages, and penalty is considered as an act of terrorizing. Hence, the courts refuse to enforce it, awarding the aggrieved party just a reasonable compensation. The courts quite despise the entire concept itself, pushing it aside as terrorism. The Indian courts, on the contrary, do not distinguish between the liquidated damages and the penalty by just awarding a reasonable compensation to the aggrieved party, which shall not exceed the amount mentioned in the contract. And I would like to draw your attention to another landmark judgment of Oil and Natural Gas Corporation versus Saw Pipes Limited. And this case laid down guidelines for deciding a reasonable compensation in the event of the breach of a contract. And that concludes my analysis.